After 11 modules of the discourse, we come to the final module, a module to reflect upon and examine the entire legal order in a nutshell, to do a bit of a review and then draw lessons from that. And hence, the title for this module is Environmental Legal Order and Learnings from the Discourse. We start with policy, law, and institutional arrangements, then move on to the adjudicative process, and finally examine the whole legal order and what are the takeaways from this exercise. The discourse, Constitution of India and environmental governance, administrative and adjudicatory processes, is a very humble attempt to introduce the aspirant to a fascinating aspect of law, to acquaint him and her with its content and contours. It's more than a bird's eye view into an ever widening arena of activity concerning environment. The idea is to review in this module the entire environmental legal order in one snapshot to assess the approximation and conformity with the constitution letter and spirit of resource management and its relative status in this brave new world of the new economic order of development. This is a virtual recap and also an evaluation of different aspects of environmental law and governance as a takeaway of this learning. Also an attempt to have a gentle peep into the future of shape of things to come, and hopefully a few suggestions for reform. Let's begin with the policy and law as prevalent in India. And if I can just put it in about 8-10 points as to what are its principal features. If you look at the policies and laws and the institution of management created under them in India, they have never ever been at all times an outcome of a natural progression, a felt need, crystallization and articulation of political and legislative will as reflected through a policy or a law, having within it institutions for management, which is embellished with procedures, plans, and programs of action as a seamless, continuous, and logical process to address the problem and find solutions. But none of this, as you have witnessed so far, has been the feature of Indian policy and law concerning environment. There is nothing like a logical sequencing of this kind of policy following the law. Yes, we have an example in the forestry sector. Law came earlier in 1879. Policy followed it in 1894. And policies do not always lead to law. You look at the water sector. In 1988, we came up with a draft policy. 2002, another policy. 2012, another policy. Where is the law? Laws are not necessarily having a policy backup also. So there can be a law without a policy backup. Yeah. Nothing exaggerated here. As you have seen for yourselves, the Water Prevention and Control of Pollution Act and Air Prevention and Control of Pollution Act did not have a policy backup. They just came. Or it's quite possible that policies may follow laws also. The next feature of the Indian policy and law is supposed to be anchored to a constitutional directive. The directive on resource management. As you have seen in the directive principles of state policy with regard to access, use, and management of resources, an obligation imposed on the state as a public trustee to take care, to protect, and to improve its quality, and similarly, the fundamental duty of every citizen as an environmental steward. None of these necessarily inform or influence policy or lawmaking on environment and natural resources. The other feature that you notice in the Indian environmental law, in terms of the language used and the stuff it is made of. Just to give an example, the Biodiversity Act. Look at the language used, which is quite loose, and the construction of the statute is not that very tight, and because of which, to a large extent, a wonderful law in terms of ideas, but in terms of its construction, for the flaws that it has, less than satisfactory environmental governance is the end result. If you turn to the judicial interpretation of policies and laws, you see a silver lining here, at least in the initial stages. Very helpful in order to cover for many of the flaws, warts, and weaknesses in the construction or making of it, or even working, and they helped in re-anchoring environmental governance to constitutional commands. Remember the public trust doctrine. And even bring in legislative and administrative reforms on waste management, public hearing in environment impact assessment, as we have seen in the earlier modules. If you closely examine the law as we go deeper, the induction of Indianness and the constitutional ethic of environmental stewardship in the policy and law is more of a fairly recent phenomenon, that too of a last couple of decades. And that's also on account of, to a large extent, on judicial nudge that I and you, as the stewards of the environment, is something that the court had to convey time and again, and also, of course, the activist efforts and institutions, which actually made people closer to environment and environmental governance, and also derive their rights from the kind of laws that environmental laws were made of. The Forest Rights Act, as you have seen, made in the year 2006, declared that this is a law to correct the historic injustice of non-recognition and denial of rights of the forest-dwelling, tribal and other communities. So that way, you do have a judicial trigger to lead to the people's engagement, people's involvement, communitarian ownership, communitarian entitlement and partnership in managing environment. Let us just turn a little specific. In terms of policies, pick the example of the environmental policy document of 2006. As you know that there was already a lot of law concerning environment. The Framework Law of Environment Protection Act was made 2 decades earlier, as early as 1986. No policy backup, and now policy comes, makes a very grand entry, although it's a little too late in its formulation and articulation. A bulky document of about 60 pages, cramming every possible concern and strategies for action. But it's more of a peroration. And if you closely examine the document, there doesn't seem to exist a very clear, concerted, conscious, and evident effort in consolidation and incorporation of various sectoral policies, or even in inspiring and influencing the formulation of the sectoral policies in different sectors of environmental governance. even with regard to concepts, principles, and strategies, you find the document a bit vague and confused. The other document, an important policy document if you want to call it, although the title is a little interesting if not vague, National Conservation Strategy and Policy Statement on Environment and Development, made in 1992, and the Policy Statement on Abatement of Pollution. So you have such a huge document, looks like, title wise. But if you just look to the content part of it, actually it is of a few pages and it is quite general in terms of taking stock and even a little sketchy in unfolding of a vision and a direction. And one would not be wrong in drawing a conclusion that these appear to have been prepared in a hurry to meet the date. Which is the date? The date of the Earth Summit, if you recall, the 1992 Global Environmental Summit on Environment and Development. And so we were to go there, participate in it, and we had to show to the rest of the world that we are doing something on the policy front. And hastily we prepared a document, and lo behold, you have this conservation strategy and policy on environment and development and a statement on abatement of pollution. Title grandiloquent, but content very deficient. There is no novelty either in giving a new thrust or coming up with a novel and effective tool for governance put together in this document. What you do see is there is more of emphasis on preventive action and promotion of clean technology without giving any details there. And there is also a talk about public partnership there in these documents, but it is visualized more as an awareness campaign. I don't know how you forge partnership through awareness campaigns. And funnily, it is there in this document of giving a pat to public interest litigations. How could that be a public partnership? In fact, public reaction to misgovernance or poor governance or inaction and knocking at the door of the courts of law for environmental justice. Public partnership for what? In fact, one is not wrong in feeling that this document, that if at all it were to have been minutely scrutinized in a global summit, they could have better avoided such a kind of a mention, at least this part of it. Then we move to the next policy document, which is fairly recent, and that is with regard to urban policy. It's a framework document of 2018. 2018, yes. Did we have a policy frame earlier? Yes, in patches and bits, but not a comprehensive one. And that's what we get now in 2018. What does it do? It lays emphasis on urban poverty reduction and promotion of the role of cities in sustainable development. And these are the only things that have something to do with environment. Let us do a bit of a contrast. How such policies are written, articulated, and how they are put into application. In the Organization for Economic Cooperation and Development, the European group of nations, they have a policy document which is made 2 decades back, and it pays a detailed and focused attention to issues concerning climate change, water governance, and developing resilience. That's what you look for, because urban agglomerate that we have is the real source of huge pollution, waste, and all that which is environmentally degrading. And so you should have had a sizable section of it, of the policy document, getting devoted to environmental conservation and protection, restoration and recovery. Hardly there in this document. Then we get into something which is a kind of a showpiece, the National Forest Policy of 1988. In my reckoning, it is perhaps the only major policy document on natural resources in India at that point of time. And this is one of those very few policy documents that lays a lot of stress on the distinctive features of Indian ethos and values of conservation. By doing what? By recognizing the symbiotic relationship between the forests and the communities of people living close to it. Maintenance of environmental stability through preservation and restoration of ecological balance, and recognition of the role of local communities in that regard, in addition to enabling and facilitating the meeting of requirements of fuel, fodder, minor forest produce, and timber needs of rural and tribal population embellish this document. The policy document, by re-emphasizing these aspects which are very basic, which actually bring the connect between the people and the forest, visualizes forestry as a strategy for combating climate change. This comes in the year 1988. And remember, the Climate Change Convention, the Framework Convention, comes only in the year 1992, 4 years hence. It introduces some new concepts as it happened in 2018, the new document, which is 30 years advanced to what was done in 1988, which introduced this novelty of strategy for combating climate change. It introduces quite a few new concepts: economic valuation of ecosystem services, forest certification, National Forest Ecosystem Management Information System. All these appear to be a fairly advanced approach to forest conservation and management, and it looks like a very professionally evolved document of 2018. It proposes a public-private partnership model for afforestation and reforestation activity. There is a sour note here. Its object of relaxation of regulations to meet the demands of development, and especially those industries which are forest based, is a bit debatable. Is a bit debatable for the simple reason that you have a different vision of the forest. And we had discussed in great detail what are forests for. While the first part, all that we have discussed so far, as has been reflected in the 2018 document, appear pretty good, the latter part gives room for a little doubt as to why for this policy has been made. Is it to promote certain kinds of development which will actually have an adverse impact on the forest coverage, the quality and intrinsic value and worth of the forest resources? That requires a little bit more debate. Luckily, it has not become the policy document, it is more of a draft. Other than that, there are more action plans available. There is no policy pronouncement made for wildlife and biodiversity conservation and their management, although we have laws on that. And the need remains for evolving a comprehensive policy that would cover all these greener aspects of environment. Still, the agenda is not accommodated. Then you turn to the other natural resource, the water. With all those tentative attempts of 1988, and then some kind of a formulation, the center making itself brave to foray into the state subject and come up with a model policy document in 2002, gets revised in the year 2012 and definitely contains very impressive components of environmental conservation and management principles and even programs of action. In fact, it is also endowed with a very comprehensive conceptualization of water, how to visualize water, and not to really think in segments or compartments, but as one single continuous whole of an ecosystem. And although this is a state subject, the central policy is supposed to be a frame, a guidance document for the states to follow. But to bring in that central element, this policy emphasizes more on interstate river linking, basin transfers, and management aspects. This policy of 2012, right now in this year 2020, is under review. The idea is to incorporate some of the new, current, emerging challenges like climate change and to explore scope for more efficient alternatives to state management model, etc. So water policy is still a house under construction. If that is the overview of the policy documents that we have, a quick look at the sector specific laws. At least we have to give it to the policy documents, by and large, echo that sentiment of activities and actions and visions for more an environmentally benign set of activities. But unconnected to these sentiments, we have laws made for the simple reason that laws are made at different points of time. So in terms of accommodation or absorption of policy sentiments is not something that you always look for when you look at a law. As I have explained earlier in fairly great detail in the specific modules on these, that there is a clear disconnect between policies and laws, and many a time you start wondering as to the need for that kind of a formulation. Is it just to fulfill a formality, or is it something to really do very concrete as being really serious about and have a focused attention in having better environmental governance? Look at the overarching law, the Environment Protection Act. What are you looking for? What are your expectations? Something which is all encompassing. But we know that as we have examined it in detail, it provides neither the required overrides nor encompasses every aspect of environment. I don't think I need to give details. Please look to those aspects of the module which elaborates on this. And there's a clear absence of harmonizing any harmonizing element in governance in different sectors, of knitting them together, meshing their functions, complementing each other's activities into one homogeneous whole. It does not provide an institution of oversight or mechanism for coordination, while the coverage and sweep of this body of law, especially the rules, regulations, and notifications made under it, are pretty impressive and very wide. Look at that. From land use planning under the CRZ law, or essential functions of local body like solid waste management, of incorporating the science and technology aspects, which is actually the primary realm of the Science and Technology Ministry, like setting of standards in pollution control regime, or even making a foray into water resource management by coming up with rules and regulations with regard to groundwater management and guidelines and rules with regard to wetlands conservation, protection and management. The sweep is very wide, huge, and ever expanding. But one thing that you can really discern from those early days of lawmaking from 1986 to maybe till around 2010 or so, there is a clear leapfrogging a vast improvement in the rule making process. At least you can see a greater degree of clarity in identification of the actors, their role, responsibilities, functions, and a clear delineation of each one of these, besides simplification of procedures. One wonderful example that you have is the rules with regard to solid waste management. We have discussed that in the earlier module. Please refer to that. What you do see is something unplanned perhaps, unheard definitely, and something even unprepared for as far as the pollution control boards are concerned. A lot more functions are assigned to the pollution control boards with each and every notification. But not much thought is given. How do you equip them? How do you facilitate their functioning? How do you build their capacity when they take up these new and ever-growing portfolio of assignments? A disturbing feature of new set of legislative reforms also we have witnessed. There's a clear dilution, reduction in rigor and effectiveness in governance. Look at the notifications with regard to environment impact assessment. And the latest one is something mind-blowing. The EIA draft notification of 2020. You know what it does? It introduces a good faith clause. Over whom? Good faith over the violator of the procedure and validating a violation by accepting a fine. And many a time you start wondering whether such a kind of thing would really do justice to the very idea of environment impact assessment, the rationale behind making such a kind of a law. These are a few worrisome features as they are emerging now. Turn to the legal regime on forests. You have a clutch of laws, and each one of them are made at different points of time. And this is very educative. The laws made at different point of time, they reflect the mood and sentiments of the polity of the time. Right from the time of the British to immediately after independence, a quarter century later, and then fairly recently in this particular decade, they really reflect the thrust, the emphasis, and the approach of the policy maker, the lawmaker, the decision maker of that time. Obviously, as a result, it presents a contrast of perceptions in terms of objectives and approaches among them. Forest Act, for instance, manifests an expression and extension of the eminent domain notion. State owns everything. A notion which it derives from the land law scheme with a little sprinkling of ethics of conservation and protection. Turn to Forest Conservation Act. Its focus is on central oversight and control over state actions with regard to diversion of forest land for non-forest purpose. The Forest Rights Act has a different focus altogether. It carves out a human exception to the forest conservation law, and the 2015 CAMPA law entirely focuses on the ways and means of bringing back and plowing back the economic gains that you derive from the different kinds of application of forest resources for the purpose of forest management and improving the quality of governance. So, different perceptions, different approaches actually populate the entire forest law regime. Continuation of the need, feasibility, and utility of a number of statutes of this kind definitely would require a review. The idea is to accommodate and balance different and apparently even contrasting purposes and interests and approaches. Wildlife law does not do anything better. The wildlife law, as we know it, is a clear copy or a borrower of the ideas of the Endangered Species Act and the conception of national parks and protected areas of United States of America. It lacks the Indian ethos and traditions of the communitarian commensality and symbiosis with the forest and wildlife around them. Ironically, the wildlife law of 1972 and its refurbished law in 2002, it happens to be the first major legislative venture on life and life forms in independent India, but at its core, it retains a colonial and Aryan soul. We have already discussed that in that particular module. We now turn to the biodiversity law. It's a refreshing departure. It presents an altogether different picture as we've seen it. It has its heart in its right place with a robust set of objectives and principles to steer the system in protecting the sovereign and communitarian interests. With regard to what? Conservation, protection, and ensuring equity in the sharing of benefits with regard to the application of resources and the knowledges, practices, customs, and traditions associated with it. No single law does this kind of a thing as the biodiversity law has been able to put across. Besides this, it actually is a great experiment in deepening democracy, much more than what you find in the constitutional scheme itself. But it's very unfortunate that this is, which is a very great idea, it suffers from imprecision in statutory formulation and inadequacy in terms of efforts in strengthening the aspect of communitarian engagement and a poor observance of the spirit of the law in its working by all concerned. And you know the end result. This inadequacy has been taken advantage of by unscrupulous commercial interest and even some of the irresponsible research community as well, to the detriment of the achievement of the goals of this law. So overall, how do these policies and laws wrapped together present themselves in the Indian firmament? Yes, they're good in parts, in terms of objectives, as far as intents are concerned, in evolving principles and purposes, they're quite robust. There is no second opinion on that. But their articulation and expression in legislative form, they require a lot of clarity. And there is a need for a more professional touch to overcome the so-called manufacturing defects in them and even to strengthen the institutional arrangements to make them effective. Much more than that, this is something which is imperative. These reforms are required to ensure that it should become fully in sync with the constitutional commands of public trusteeship and environmental stewardship so as to make the legal system towards a more environmentally benign, sustaining, developing activity and a system of governance, which we should feel proud about.